How does Texas family law affect your gun rights? Family cases are tough, emotional legal controversies that sadly have become a part of too many Americans' lives. But did you know that there's a standardized, boilerplate Texas temporary restraining order that can turn lawful gun owners into federal felons? Most people know that a proven allegation of family violence that results in either a protective order or a criminal conviction will result in the loss of somebody's gun rights, and if they're a license holder, will result in the loss of their license to carry a handgun. Both Texas and federal law prohibit someone who has been convicted of a misdemeanor or felony crime of family violence, or they are the subject of a protective order, from possessing a firearm. Most people would agree that this is a reasonable prohibition after a person so accused has had their day in court. However, what you probably did not know is that in almost all divorce cases, a Texas court will issue what is commonly known as the Standard Temporary Restraining Order. This order will tell the parties not to fight with each other, hide the children from one another, destroy marital property, spend marital funds, open each other's mail, disconnect the household utilities, etc. Basically, it's the court's way of telling the parties to behave like adults and act with common sense. However, the first 5 provisions of this order direct the parties not to harass, stalk, injure, or be violent to the other person. While this may seem reasonable, the courts will usually order it in all cases, including cases where there has been no allegation of family violence by or against either party, nor has there been any evidence presented that there was ever family violence in the relationship. In fact, there may be a situation where 2 lawful gun owners are getting a very amicable divorce, but a family court goes ahead and enters the standardized temporary restraining order because, quote, that's the way we've always done it. And because they've entered that order, both parties, when they are in possession of their firearms, are now in violation of Title 18, Section 922G of the United States Code. If you don't think this can happen, it already has. In the case of United States v. Emerson, the Fifth Circuit Court of Appeals held that while acknowledging that this order is pervasive and given in cases where there has been no showing of family violence, that it is in fact an order that is designed to prevent family violence, therefore is a lawful prohibition on firearms ownership. A word of warning to you if you find yourself unfortunate enough to be involved in a divorce. You need to find yourself a lawyer who is very familiar with the impact that the Texas Family Code has on your gun rights.